From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Special counsel Jack Smith files a new brief in his January 6th case against Donald Trump, unveiling a bevy of new and unflattering details to support the prosecutor's claim that the former president engaged in criminal conduct. What's in that brief? Does it comply with the Supreme Court's ruling on presidential immunity? And coming as it does a month before the election, does it count as election interference? Welcome to Potomac Watch. I am Kim Strassel, and answering those questions for us today are my two esteemed colleagues, Mene Ukwe-Barua and Bill McKern. Welcome all. Just a little quick background here. The Supreme Court in July ruled that former presidents are entitled to some level of immunity from criminal prosecutions, absolute immunity when it comes to exercising core constitutional powers, but also presumptive immunity for some of their other duties. This caved a big hole through the center of Smith's indictment, and it made it clear that we now have to engage in this long process in which Smith and the Trump legal team argued in front of a judge over what pieces in his indictment that remained were covered by immunity or not. Maybe a couple more trips up to high courts, but in any event, no chance of a trial before the election. Now, my own view is that coming as this did as we were barreling into the height of a presidential election, this probably would have been the time for Smith to step back, say, okay, I put all my stuff out there. Let's let the election run its course. Let's let the American voters render their judgment. I will regroup in November. Mene, that is not what he seems to be doing. What is Jack Smith up to here?
Well, I think that there's really only one way to read the timing of this filing, and it's exactly as you mentioned. Jack Smith made a calculation that he wanted to be able to have an impact on the election by revealing some of these damning details about Trump's conversations regarding election fraud after the 2020 election, but he wanted to do so in a way that had a little bit of deniability. Traditionally, the Justice Department has an unofficial rule of avoiding anything that would have a major impact on elections within the 60-day window, which we're well within at this point. And to cross over that, you would generally have to have a very strong reason to do so. And it's hard to find from a legal standpoint what reason Jack Smith had for doing so in this case. I think that he knows, of course, that the continuation of his case is going to depend on a Kamala Harris victory, obviously, because if Trump is elected, the first thing he's going to do is fire Jack Smith and proceed as normal with his own course and restored to the presidency. And so Jack Smith, instead of taking the time in the aftermath of the Supreme Court's ruling on immunity and saying, let's go very carefully through all of these charges, all of these details, find what we can take out, what might really be outside the outer perimeter of the president's powers, and then bring that. He clearly decided, I want to steamroll ahead with the hope that if I'm able to get this monster brief in the public eye, it might actually help to ensure a Kamala Harris victory and therefore the continuation of his case.
Yes, that was an interesting part, the monster brief. He actually asked for special dispensation to file a brief that was multiple times larger than what is usually allowed in this district court's page limits, and also to have it unsealed, which does look a bit suspicious here as well, too. It didn't have to be unsealed. He didn't have to ask the judge to do that. By the way, neither did the judge have to do that either. She played a role in this, too. But Bill, let's drill into this point that Mene made about this 60-day rule. If you were to talk to the left, I'm assuming if you were to talk to the Smith legal team, they would push back. They would say, we're just interested in the swift carriage of justice. We're all about law and order. I did actually even see his legal team. This was regarding the classified documents case, but they were asked about this by the judge, and they kind of cited this foot fault on the 60-day rules. Well, we're not supposed to take major actions within 60 days, like filing a suit. But if you're just engaged in ongoing litigation, that's a different thing. I find that kind of hard to swallow. I don't know what your view is, Bill, but it just strikes me that you're within about 30 days of an election and you release this massive 165-page brief full of all of these damning details and information. I don't know. What's your view on Justice Department policy and what's happened here?
Well, I share your view, but I am not surprised. I want to preface my remarks by focusing on Jack Smith. I think he was temperamentally unsuited to be a special prosecutor. And I really don't believe in special prosecutors. They're an aberration. They do things differently. They're not accountable. There's a question of his own appointment because he wasn't Senate confirmed that I think is a very important question, won't be answered till after the election. But all those things go in. He was rebuked by the Supreme Court 8-0 regarding his prosecution of former Governor Robert McDonnell of Virginia in a big case. It changed the way we look at public corruption. And I just think you don't pick, even leaving aside the question of his confirmation and problems with the special counsel, you don't pick someone like that to handle a case involving a president. You want someone judicious who's going to dot the I's, cross the T's. And I think he's given us all specious arguments. His argument, for example, is that the public deserves a speedy trial. That to me sounds a lot like some sheriff in the Old West saying, well, the public deserves a hanging real fast. The speedy trial is supposed to benefit the defendant, right?
Right.
Not the other side. So I share your concern. Everything's political about it. Of course, as his legal case seems to become more iffy, I think his political case has not become stronger, but more a focus of his actions. Because after the election, I think a lot of this is redundant. If Trump wins, it'll obviously go away. I think if Harris wins, it'd be less important and so forth, because the real import is to guarantee that Trump loses.
Yeah. You just touched on my frustration with prosecutors in general, which is too many of them forget when they go to the Department of Justice, they say an oath in which they, pledge their fidelity to upholding law. And that means taking into account, by the way, the rights of defendants. And too often they are more interested in putting scalps on the wall. And that's not really the administering of justice. But Monet, a last question here. I want to dig into his actual brief, but one last question. Where's Merrick Garland here? I mean, we last saw him complaining that people are unfair to the Department of Justice and impugn motives to the Department of Justice. I mean, this does not look good for the Department of Justice. Presumably, Jack Smith does still report to the AG, who does control the DOJ. Why is he MIA here?
Well, sure. I think that there's very little chance that Merrick Garland is going to address the press on the release of this brief. But if he did, I think we've heard enough from him in the past to expect what we would hear. He would, in his classic monotone voice, say that there's nothing going on here except the disinterested administration of justice, and I have full confidence in Jack Smith to execute his duties, and that any relationship between the timing of the brief and the election is purely coincidental. I think that this is exactly why the special counsel system exists, to get to Bill's point, to essentially allow the attorney general and the president to create the illusion of remove from these actions, even though everyone understands that at the base level, there's at least some degree of coordination or meeting the expectations of what the attorney general and the president are. And so I think the public is really ill-served by the Justice Department being able to duck accountability for a release like this.
Yeah, down with special counsels. We're going to take a quick break. When we come back, more on Jack Smith's brief this week on the Donald Trump case. We are back. Let's turn to what's in the brief. Look, a lot of it seems to focus, reading through it, on Trump's state of mind leading up to January 6th. I'm assuming that's in there, by the way, to bolster an argument that Smith now has to make that Trump's actions were done on behalf of himself and for his campaign and not for any official purpose. But, it's basically more examples of Donald Trump supposedly being uncaring. I mean, there's an anecdote that's being thrown around from the brief that the president was told that Pence was being evacuated out of his Senate office because rioters were not far away. Apparently, Donald Trump said, so what? Some things about statistics he might have invented. I don't know. Bill, what stood out to you in this brief?
What stood out is just the politicized nature. It's not about securing a conviction. It's, as you suggest, about dropping these incendiary charges in the public square just a little over a month before the election. So yes, it looks bad, but of course, all prosecutors' briefs look very bad. If you just read a prosecutor, you say, "Oh, this guy is guilty as hell and should be convicted." It's not until you see what the defenses are. And I think we learned a little from Jack Smith, when he was rebuked by the Supreme Court for not addressing those immunity claims. What did he do? He went back and changed a few commas and everything and a few phrases, but the same charges, and it just contributes to the view, which is true, that this is all about politics and less about a conviction. And Jack Smith knows, if he succeeds in this, if Trump is defeated, he'll be hailed as a hero for this. And that really sticks in my craw, because for all the claims about Trump as a threat to democracy and interfering in elections, Donald Trump behaved abysmally during January 6th and the events leading up to it. But I think his misbehavior and his threats are always clumsy and out in the open and frequently not supported by his staff. And I think Jack Smith is an example of what the other side does. It's sneaky. I think it's a threat to our justice system. I think Merrick Garland is part of it. As you suggested, the appointment of Jack Smith was to say, we're going to indict the rival candidate for president, but we have nothing to do with it, even though I'm head of the Justice Department. I think Monet suggested that. And he's been allowed to get away with that. And I think those threats are more insidious, not to mention problems with the FBI and so forth. And I think they really have a lot of Americans worried. I mean, the irony is politically, they seem to have had the opposite effect, making Trump's support among the supporters grow rather than diminish.
Well, let's talk about some of those unflattering details that Smith chose to put into his brief this week and how it works in terms of that brief with complying with the Supreme Court ruling back in July. As Monet suggested, and you've talked about too, Bill, he rushed out with this superseding indictment in August. It was really striking because it contained the same 4 charges. Really, he only got rid of basically one thing, and that was the thing that the Supreme Court directed him to essentially take out, because they said it was conversations that he had had with Justice Department officials, i.e. members of his cabinet, could be or should be construed as part of the president's core constitutional powers and therefore were given immunity. So he took that piece out. He basically left much of the left in. And the question now hinges on the rest of the Supreme Court ruling that said, okay, there's these core things, you can't use them. A lot of other presidential actions have the presumption of immunity, and it is the government's burden to overcome that presumption, to somehow show that that doesn't count. And they gave an example of this in the Supreme Court ruling. They said, for instance, the president's conversations with Vice President Mike Pence, you cite them quite frequently, and the conversations were about Pence's role in going to count electoral certificates on January 6th. That is actually a duty laid out for the vice president in the Constitution, and at least then by statute. And so it has a presumption of immunity. You have to explain to us why that wouldn't have immunity. So Monet, Jack Smith goes at this in the brief. I didn't find it very compelling, but what does he do and what's your thought on it?
Well, in the brief, Jack Smith is articulating a vision of the outer perimeter of the president's powers that is almost laughably narrow compared with what the Supreme Court laid out in the Trump versus U.S. decision. Smith, in one section, describes how the president doesn't have a formal role in certifying the electoral count. Ergo, any involvement that he has in advising the vice president not to overturn that is not a presumptively immune outer perimeter duty. It's merely electioneering. It's the president acting in his private capacity as a candidate rather than as the president. But that really doesn't jibe with what the Supreme Court says. The way that they describe the outer perimeter is essentially duties that might not be specifically enumerated in the Constitution as things that the president must do, but things that presidents do and historically have done in their role as chief executive of the nation. President Trump obviously is in charge of making sure that the laws of the United States are faithfully executed. And if he believes, as he really really seems to, in anecdote after anecdote, even that Jack Smith affirms, that there was election fraud. He has a responsibility as the chief of government to make sure that these are investigated. So those aren't core presidential powers that have absolute immunity, but they very clearly, by the standard that the Supreme Court has laid out, are within the president's role and therefore have presumptive immunity. And it seems as if Jack Smith very, very willfully tried to shrink down that perimeter to a point that is really completely unsustainable.